Good afternoon. Chair Tumulty, Chair Gonzalez, members of the committee, good afternoon. My name is James Keown. I'm an incarcerated patient in the medical unit at MCI No Shirley, and I'll be speaking today in support of Senate Bill 1535 and House Bill 2319. Neurologists have diagnosed me with a progressive neurodegenerative disease that affects my ability to walk, to breathe, to eat and drink, to use my arms and hands, and to sit upright unassisted. I rely on many aids to carry out basic activities of daily life and require the assistance of others to button a shirt, tie my shoes, or put on a jacket. In 2021, DOC doctors found me to be permanently incapacitated. That determination has been supported by almost a dozen specialists and objective medical tests. The DOC also found me to be low risk for violence and recidivism. Agency records reflect that I have remained disciplinary report free for more than 18 years and have been active in programming. In the face of these facts, however, DOC Commissioner Carol Michi has repeatedly denied my petition for medical parole. Instead of following the medical determinations of a multitude of licensed physicians who have evaluated me, the commissioner has diagnosed me herself with a condition that I've never even been tested for. The commissioner has also ignored her agency's own data that show me to be low risk and chosen to assess my risk with not much more than her gut. My case is far from unique. I am housed at MCI Shirley and previously MCI Norfolk with many other patients who have endured similar experiences. Many of these people are as disabled as I am, some far more so. I am surrounded by people with dementia, cancer, and other disorders, as well as those who have had toes, feet, and legs amputated. In addition to those of us with serious diseases and disabilities, there are also dozens of men in their 70s and 80s whose frail conditions require daily assistance. As medical parole stands, there is no functional remedy for a person who the commissioner wishes to deny, regardless of her lack of reasoning or lack of evidence. The court can currently only remand petitions that were determined wrongly. That has left many qualified petitioners trapped in an endless loop of improper denials, followed by court-ordered remands. Tragically, I've watched patients, friends, trapped in this cycle die, awaiting a valid review. Now, there is a belief among some that medical parole is a get-out-of-jail-free card for the seriously ill and elderly, but nothing could be further from the truth. Medical parole does not allow for anyone to walk free. It instead provides for sensible, alternative state supervision in an environment more appropriate to a person's condition and risk level. This bill fixed defects in the current law made apparent over the past 5 years, provides for better accountability and transparency, helps stabilize and allocate the DOC's healthcare spending, and acknowledges that in a modern society, concrete and steel boxes surrounded by fences and razor wire are not the only spaces where incarcerated people can safely be supervised. I encourage you to support this bill. Thank you for your time today.
Thank you very much, Mr. Keown.